Доброго дня, шановні колеги.
Good afternoon, esteemed colleagues. Today, the International Charity Organization, Environment of Human Rights, together with the Open Society Organization and the US Embassy, will be presenting our paper, the draft basically paper, which is dedicated to topics which are to help Ukraine to get rid of the situation that we have now. In Ukraine, we have amber republics, and the country is losing millions and millions. A lot of harm it causes to the environment. We have the judiciary, the strong civil society organizations, the law enforcement bodies, but all these problems continue. We see what's happening with the forests and what to do with that. We are now approximating our legislation to European. We are happy that we have the association agreement. We have about 100 new laws, but certain things do not work. One of the problems is the problem of non-effectiveness of the institution of legal responsibility for offense. One of that is that the criminal law does not cover all the criminal offense. Also, there are no institutions of criminal administrative responsibility of legal entities, and these are just some of the components of this problem. The problem is huge. To cover it by one analytical paper is impossible. That is why today we got together in order to present the aspects that we would like to emphasize. We would like to discuss the problem. We hope that the dialogue will be constructive.
Ми все це проаналізуємо.
Then we will analyze and supplement the document, and we'll be working on the draft solutions of how this problem could be addressed. So now we will take from 7 to 10 minutes for the presentation of our expert group. Then we'll give the floor to experts. We invited the researchers, our ministry, and the experts of the EU representative office and the representatives of eco-inspection. So the speakers today, the participants, are people who have their own vision and ideas. Now I would like to give the floor to Elizaveta Alexeyeva, Head of Information and Analytical Department, and she's also heading this small group which was drafting the document.
Доброго дня, шановні колеги.
Good afternoon, esteemed colleagues. I'm also happy to see you. Your contribution into our work is very valuable. Thank you for coming. I would like to thank Elena because he explained what we are doing. I will start presenting the document. First, what I would like to say, we do understand that the problem of legal responsibility in the sphere of environmental protection is not effective, and we understand that it is also important that there is the punishment for any type of offense. One of the reforms should be about that. The paper that we are presenting, we are first of all looking at the reasons of responsibility, also the issue of efficiency of control in the environmental sphere is a different issue. This is beyond the framework of our today's research. A little bit about format. Instead of immediately starting to draft the regulations, we are trying to do it based on European traditions, and first we would like to outline the problem and preparing the green paper. What's the green paper? The green paper formulates the reasons why the legal responsibility in environmental sphere is not effective. So the result will be the document which is the green paper, and it will describe all the problems. The next step is preparation of the white paper, which develops political solutions, and after the political decisions after the political solutions are executed, after that the draft bylaws and regulations are developed, and that is the further stage of reform. Now we are at the first stage, at the stage of drafting the green paper. Addressing the issue of whether legal responsibility in the sphere of environmental protection is effective or not, we were looking at whether this responsibility executes four main functions, whether it stimulates following the requirements of environmental legislation, the compensation and others, and the main problems or the gaps which we found out, we formulated in accordance to four classical types of responsibility: criminal, administrative, disciplinary, and civil. Talking about criminal responsibility, what we saw, the criminal law does not cover all environmentally hazardous actions. One example, Ukraine is the party to the Convention on Prohibition of International Trade of different types of flora and fauna. One of the commitments is that Ukraine has to provide for effective punishment for such activities. In Ukraine, criminal code does not criminalize such offense, but the civil code has this, and the maximum sanction is €6. In Holland, for example, the criminal responsibility is 6 years of depriving of imprisonment, basically. Just compare €6 to 6 years of imprisonment. Also, another responsibility is that the measure of punishment for environmental offense is very low. the consequences of environmental crimes could cause to the death of not one person but many people. It could harm the health of many people. There could be big losses for environment for hundreds of years. And if we compare that with the murder, because of the person was not careful, when in the result one person was killed, the punishment is the same. And one more element, the fact that there's no institution of criminal responsibility of legal entities. We know that the recent amendments to the criminal code provide for the possibility to apply criminal measures to legal entities, but the crimes are very limited, and the environmental crimes are not included into this list, and that is a big problem. We need to correct this situation. Also, the Institute of Criminal Law Measures provides for additional punishment which is not used in other crimes related to physical persons. Like we're talking about high fines and suspending the activity of legal entity. Talking about environmental crimes, we offered to expand that list and also expand the list of sanctions. To introduce the sanction like liquidate the contamination or temporarily stop the activity of the company. Talking about administrative responsibility, first of all, we know that administrative code covers only physical persons, and the result is very low sanctions. But the sanctions are just funny, starting from 17 or 50 hryvnias for environmental offense. A big gap in the legislation is the fact that we don't have the institution of administrative responsibility of legal entities for environmental offense. In our legislation, we do have such a scheme when it comes to violating legislation of financial regime or some others, and it provides for very high fines or canceling licenses, for example. This is not used in an environmental sphere. There were certain things introduced into the new law, and Dmitro will talk about that, and I also saw it in the draft law on waste, on packaging. There are certain sanctions included into that law. Also, the restriction or temporary suspension of the activity of the company which violates the legislation. This was the sanction in our state a few years ago, but a few years ago the regulation which provided for such procedure was cancelled. In fact, this mechanism is not operating. I believe it could be very efficient. Stopping the activity of the company forever. This could be decided by the court only, but suspending the activity of the company. That is what a controlling body could do. And one more thing that I would like to mention, these are methods and taxes.
Є заниженими в деяких випадках.
The fines which are to be paid for the harm caused to the environment. These fines are inadequate and very old. In some cases, they could be very high, and then they are the element of corruption. Our legislation doesn't provide for mechanisms of using the funds, such funds for measures to restore the element of environment that was harmed. In the best case, this money will go to the special fund and could be used for anything.
Почути ваш фідбек, але однозначно не використовується.
This money is not used to restore the natural resource which was harmed. Also, it would be feasible to think and offer to introduce the institution of mandatory insurance, because certain accidents could have such global consequences that not every business will be able to cover that. And for that we need to have this mechanism of mandatory environmental insurance. On that I will finish and will be happy to get any comments, any proposals from you. Thank you.
Thank you, Lisa. We started the discussion and we will continue. And we will be glad. The topic is difficult and we won't be able to discuss it during 1 hour, and we are open to all written proposals. Each proposal will be dealt with and will be taken into account. And I now give the floor to Irina Vaityuk, Rector, founder of the Academy of Judges, head of board of our organization, in order to continue. And also there are several other experts. So please, you can focus on the main ideas, and we provide 1 minute to each participant. Good afternoon, everyone. As of today, legal responsibility on violation of environmental law do not lead to the improvement in the area. And they get some benefits and do not repair damage. They sometimes pay fines, and the responsibility should be established adequately, and the Institute of Legal Responsibility should be introduced in this area for legal entities. And also I agree with my colleagues that all fines and payments for violations should be used in order to repair the damage and harm that was caused by actions. And the mechanism and the legislation in this sphere provides that the activity of enterprises that violate legislation, that their work should be stopped. So the body cannot influence the entrepreneur if he harms the environment. He cannot stop him in this, to stop his activity. He should take decisions, and this enterprise continues to work. So this is a gap. And there was provision of the Supreme Council, and whether this provision is adequate and sometimes legal entities believe that this is unfair and there is corruption component in this, and control bodies do not have a responsibility for stopping this activity. So this is one of the ideas I wanted to say. So we have second presentation with brief ideas that we want to provide in order to focus on the main points. I give the floor to Irina. Thank you. Good afternoon, dear colleagues. Several aspects I would like to draw your attention to, continuing the discussion we started. First, we do not have comprehensive approach on reforming the legislation in the state. So the attempt of ecology, right, and human entity is an important aspect in the area. And also the reforms should be made on a concept level. First, green paper is created, then a white paper is created, and this is important, that this is a systemic approach. And we believe that this approach should be used in other areas. And second, if we are speaking about legal responsibility and criminal responsibility, administrative responsibility, specialists of ecology law and human organization, the experts of this organization state that there should be amendments introduced in laws, and also there is another side of this problem, is the implementation of this legislation. And if we look at statistics of judiciary that is open, you can find it on site of Supreme Court or any other court. So environmental crimes are not stated there. And it shows that environmental offenses, they are in the context of other crimes concerning, for example, criminal code, or in the framework of other crimes. And I would like to cite the words of one of judges of Administrative Court of Appeal, who said, "We are judges, we have two halves, part of the brain. One is material law, and the second is procedural law. We never think about global problems we face." And this is said in the convention that there should be proper access to information, and this is important for us and for the future generations. And it is important to work to improve comprehensively legislation, and also we should work on its proper study and implementation. So there should be responsibility, and it should be irreversible. And why there should be irreversibility of this? Because it is important to establish it on a proper level. So this is a good tone for the discussion, and I would like to give the floor to our ministry, without which we cannot really implement reforms, and only due to them quality changes will be done. So that's why we have great hopes and we want to cooperate more with the ministry, and I would like to give the floor to Šimkus, and she is going to tell us about this matters. Good afternoon, everyone. I'm glad to be here today, and it is worth saying that these are pressing issues we discussed today, and Lisa said and highlighted the main problems concerning legal responsibility, and the ministry faces these problems in its work, and we understand these problems, and legal responsibility as an institution should be a powerful indicator in the system of environment protection. But now we have a number of problems that one ministry cannot resolve on its own. And about the low fines, the administrative responsibility, and lacking of sanctions, there were some changes to these acts. We developed them, but we didn't succeed in this. But we do not stop our work in this area. Also, important issue is the existence of ecology negalism and neglect, because other bodies do not take part in the development of environmental policy, and they do not pay much attention to it. And we hope that the situation will improve, and the tasks that are envisaged by the agreement, we hope that the level of understanding of environmental issues, that the level of understanding will increase, and it will. We hope that the situation will change for the better, and we are lacking time to discuss these issues in detail, but we are open for cooperation, and we believe that this is only a start, and we will continue our cooperation. We are ready for this. Thank you, Marina. And the problems and different aspects of these problems also is of concern to ecology inspection, and for us it is important to know the ideas on these matters from the side of Ecology Commission. So now I'm giving the floor to Vasily Strashuk, Deputy Head of State Ecology Inspection in the Lviv region. So we are facing these problems and these discrepancies that are in in environmental legislation. So I believe that there should be proper changes in the environmental legislation. Otherwise, the reforms won't work. So the reforms are not the synonym of improvement. So as to limitation and time limitations, I would like to say that the main ecology environmental inspection, there are some checks that do not allow us to properly verify the situation. So without agreement of head office, we cannot carry out these checks. So when violations appear and it is short term, it is difficult to go through all the stages, and this allows the offenders to avoid civil and criminal responsibility.
I agree with the previous speakers. The existing sanctions on administrative code and also the developed and approved methodologies were there. You know that there was the inflation and the responsibility has changed. The code on environmental offense hasn't been reviewed. It's true about fines. If we look at how fines were changing in time, let's take the harm caused by contamination of water. Different methodology was reviewed. First, the fines were very small, then they were huge. Talking about Vodokanal, I believe that if there is the national program of improving the situation, we can improve the operation of the purification facilities. Also, the procedure of sanctions, which is temporary suspension of the activity, is important. Last year, this mechanism was cancelled. Now there's a mechanism of transferring the materials to the court, and the court makes a ruling. We are working accordingly, but this issue hasn't been resolved yet. The procedure is very difficult. The courts consider it normally, but at the level of execution, nothing is happening. We have the resolution or the ruling of the executor, and the executor comes to the company and states that there is the ruling of the court that the activity of the company should be suspended, and that's it. If the company was causing any negative impact, then they were really stopping the activity of some of the equipment. But now it's not happening. We were talking about making the citizens responsible. The administrative code has the personal data of citizen. Most of the citizens, they don't carry the ID with them. The legislation says that you have to identify the personality of an offender, but the police doesn't have a database. They cannot identify this person. Sometimes the person is made responsible. I will tell you about some technical things. The resolution is passed, and that means a lot of work. Then there's the law, which says, which is very detailed. Okay, the rest in the written form, please. And finally, the primary control will allow us to see the situation in reality. We have the Institution of Permits, but there's no responsibility for accounting. I'm talking about accounting of water and others. We are creating the framework, but no one's accounting for that and doesn't report on that. And the permits without real measuring, without real control, are worth nothing. I believe that environmental inspection will have many comments, and we will receive them in the written form. Our organization, despite the fact that we are practitioners, but we understand that without the researchers it is impossible to do anything. And we would like to thank Alexei, who's cooperating with us, and he's doing it quite globally. So the floor is given to Alexei Shumila, Associate Professor of Kharkiv National University of Internal Affairs. Thank you for inviting. This topic is very global, and I would like to continue the presentation of our colleague. And I would like to say, when the commercial court passes the resolution on suspending the activity, then the judge has to be made disciplinary responsible, because he is violating the law. The court doesn't make a decision on suspending the activity of the company, because immediately they will be called to disciplinary commission. And that is what's happening in Lviv. When we had the seminar there with the judges, the judges came to us and they were saying that we are called to disciplinary commission because we suspended the activity of a company. So on the one hand, this is like a democratic trend, but on the other hand, people are suffering. They're suffering because environment is contaminated, and also talking about criminal responsibility for legal entities. Back in 1996, Mr. Galavati, when he was the Minister of Justice, he signed the Convention on strengthening the criminal responsibility, and to say that in Ukraine we have some obstacles to make legal entities criminally responsible. I would say no, especially because we signed this convention back in 1996. As to making legal entities criminally responsible, there are certain issues there. The entity, so both the legal entity and the physical person who's the owner of this entity are made responsible. But when I was doing audit of some companies, I saw that in case the environmental inspection would find this company, and they had to pay some fines, some manager of the company had to pay the fine. What was interesting, like the chief engineer, chief technologist, because he ordered to make this to do something that contaminated the environment, he would receive the bonus, which was almost equal, or 15-20 hryvnias higher than the fine, and that's why it is higher, 15 or 20 hryvnias. And they said that is for this postal collection, because they had to pay extra 15-20 hryvnias when paying the fine, because this manager was compensated all the losses when he was paying the fine. Also, we need to develop the institution of environmental insurance, and that is what Azerbaijan has. They have the mandatory environmental insurance, and we would like us also to have it, and then this will be an effective way to cover the costs for, and there should be synergy in all the directions. There's a big project of the European Union, the project of technical assistance to our ministry, and I would like to give the floor to the key expert, Dmytro Strelnikov. Before I worked in the European project, for many years I've been working in the NGO sector, and the sphere of my activity was about control of transborder movement of hazardous waste and environmentally hazardous waste. And I would like to say that our project includes three main components, and that is more the support of the legislation that is in horizontal sector, different pieces of law that cover different sectors of economy.
Охорони природи, тобто безпосередньо Натура 2000 і пташина директива, які входять в цей комплекс.
Going back to responsibility, I would start from my previous experience when I worked in the project. We had a lot of communication with Interpol. Environmental crime is one of the most progressing crime compared to others. The Interpol considers them to be equal to weapons or drugs trafficking. The risks are minimum, and that brings most money. Many parties are involved into these crimes, private persons who get wealthier, or maybe the crimes are related to contamination of the environment. And in principle, if we look at what's happening in our state, in this document, we need to pay attention to the complexity of different cases. We are talking not just about the crimes in the sphere of environmental protection. There are many adjacent crimes which affect the environment. One of the examples, like there's this disaster at one of the waste dump. There's the plant next to it, which was made bankrupt in a year. There was a company that got this plant, got the loan. And if you understand the context of this transaction, the bank issued the loan and basically the pledge was the waste, the dangerous waste that the company had to get rid of, and in the result the waste is still there, and the local community is trying to transfer it to the balance of regional administration. Well, I'm talking about complicated crimes, but we need to differentiate because the problem is comprehensive, and I would like also to say that in complicated crimes, the issue of proving that that was the crime is very difficult. We need to create different institute of control. And again, this might be the next stage, but talking about sanctions, I would like to mention some other aspect. The World Bank had this project on forests, and they were saying that you need to differentiate between the crime of poverty and other crimes. One thing is when a person goes into the forest and cuts the tree for own needs, and such illegal cutting of forest add up to the statistical data. But when we see the trains at the border full of illegally obtained timber, such crimes are not punished. Back in the 90s, when we started talking about the responsibility, criminal responsibility of legal entities, many scientists were just wondering why, but now where we see when the real financial sanctions are imposed on the company, we will not be able to impose these sanctions.
Це закон, зокрема, закон про оцінку впливу.
Now the law on environmental assessment, assessment of environmental impact. There are different sanctions there, but we saw the collision that the laws on protection of environment certain rights are given to the executive bodies, and in other laws this responsibility is with the court. So this is the situation which is to be resolved.
Ілля, і в нас вже є перші ластівки, я останню просто тезу скажу, що нас...
Our law is now to be signed by the president, you know, who's requesting the veto of the president. These are Energa Atom and the Association of Pig Raisers. There are some companies in Poltava and Ternopil where the citizens are protesting against the contamination that's taking place in the result of the activity of some poultry farms or other farms. And the Association of Pig Raisers of Ukraine managed to introduce some amendments to the legislation, and now their waste is not the waste of the fourth class of hazard. As a rule, these are big agri holdings, and they take this waste to their fields. Thank you. We practically have no time left. I don't know whether we have the representatives of the Supreme Court. I hope that they will also submit their proposals in the written form. We had to have the representative of the Prosecutor General. If you are here, it is important. That's the body, and that's the stakeholder.
З ними. Будь ласка, 30 секунд, головний меседж, а далі ми з вами вже попрацюємо індивідуально.
Будь ласка, представляйтесь. Доброго дня, Скрипка Максим Вікторович.
Скрипка Максим. Yeah, this is the issue, which is very important. I do support the necessity to enhance the responsibility for such offense. And the legal entities are to be made responsible. That is important. And the General Prosecutor's Office will also support these legislative initiatives. Thank you. And we are looking forward to get a written opinion from you.
Спільно працювати. Я знаю, що є ще представник уповноваженого.
There's also the representative of the Human Rights Ombudsman. A few seconds if you have anything to say.
Я керівник управління.
I'm the head of the department on the social rights execution. We do support your initiative. These are very important issues that you've been discussing. We have many cases. When people complain that the environment is polluted and contaminated. And you can see our proposals on our website in the annual report of the Ombudsman. There's a special section there. Yes, we've read it. Thank you. We'll look at it again and we will send the document. Now there will be another meeting here. Our experts are still here. If you have any questions, proposals, they are at your service. Thank you all for joining us, for listening to us, and we'll continue our work. Thank you.
Так, дякую, колеги. Якщо є питання, будь ласка, вже прохання їх ставити в кулуарах, тому що у нас наступна подія буквально за 5 хвилин.